Good morning, or hello, Dan Marr here from Hamlin Carrigan in Nashua, New Hampshire. Today I'm going to be talking about mental competency for wills and trusts for estate planning devices in New Hampshire. I've dealt with this in the 36 years of practice litigating these matters and also assisting our Trust and Estates Department in regards to these matters. And I've done a few vlogs on concentrating primarily on what's called undue influence. Undue influence is when somebody may have either diminished capacity, but they still can sign contracts, or they might be completely capacity, but they were so manipulated by this person that their own free will was usurped, taken over, and they felt the obligation to give these gifts that they gave. Undue influence is a different analysis than mental competency. Mental competency I'm going to talk about today is really focused in on the person can't sign legal contracts. They can't sign a contract to sell their house because they're of their mental state. They can't sign wills or trusts because they're mental state. In focusing in on the mental competency issue, generally what the courts will do is often these challenges happen when the person is dead. If the person is not dead, they're obviously going to want the person in court before them to deal with the mental competency issue. There's exceptions to that, like in guardianship, when the attorney for the proposed ward asks for permission not to have that person there because they're obviously incompetent and it would be difficult for them to be moved from the assisted living. But that's different than what we're talking about here. We're talking not about a guardianship proceeding, we're talking about mental competency for a contract forming, including wills and trusts, and that's primarily where they are dealt with. My experience with those are most of the time those challenges are made when the person is passed on. So a sibling that thought that they should have gotten some money, that they thought their other sibling or maybe a caretaker took advantage of the person that was giving the gift, and they said, look, I should have gotten a piece of this and I didn't, and therefore I'm challenging it for mental competency. In that situation, you can make that challenge, or maybe you got less than you thought. You can make that challenge. If I've talked about another vlog, if there's a no contest or interim clause, you got to be careful about that. Look at that vlog and I'll explain details about that, because if you challenge and you are unsuccessful, you may get nothing. But if you're getting nothing anyway, or there's not an incontestability clause, you may feel free to go forward with the mental competency issue if you think you have the evidence. Look at the medical records if you can get those. You can get those generally from discovery in regards to the matter if you had a good faith basis to think that, say, mom or dad or whoever it was wasn't competent. But what you really have to do also is look to see the estate planning documents. Is there a attorney? If there's an attorney that's signing these documents, it's a little bit more of a challenge, because that person's probably going to be saying that I, as the attorney, when I signed this document, thought that the donor, the grantor of the will, the grantor of the trust knew what they were doing. I wouldn't be having them sign this, and I wouldn't have a client relationship with them if I didn't think they knew what they were doing. So there's a challenge there, but just because that lawyer says that doesn't mean that you might not still be able to overcome that challenge, but it will be an uphill battle. One of the things that you really have to deal with, though, in this is to come to the conclusion, be able to prove to the court that at the time of the signing of the document, the person didn't know what they were doing. By way of example, as I said in other vlogs before, they think that the daughter that's coming in is his wife. He is confused about who the president is, and it's not a political issue that they don't like the current president or they like the past president. It's not snarkiness, it's they don't know. They don't know generally what their assets are. They don't know if they own a home. They don't know if they have bank accounts. They don't have to know it down to the penny, but they don't know that general ideas that they have money at DCU or Fidelity or Citizens Bank. They don't have that knowledge. In general, that might be an indication that they don't have mental competency. They don't know who their children are or their spouse. Good indication. They have to do this, though, have this lack of mental capacity at the time that they're signing the document. Any of us have had experience with elderly parents or elderly people that we care about, and certainly myself with clients. They can be in assisted living. They can even be in a memory care unit. And there might be times when they are lucid and able to sign documents, and other times when they're not. So they can sundown, by way of example, and so at sundown they're antsy and they're agitated and they have a lot of confusion, where maybe after breakfast and they they're washed up at 10 o'clock in the morning. They might be um, attuned enough mentally to be able to sign a will and trust, and that can be a binding agreement. This is all fact specific. You should talk to an attorney if you're considering this issue. My name again is Dan Marr. I'm at Hamlin Kerrigan in Nashua, New Hampshire. Our telephone number is 603-883-5501. That's 603-883-5501. And our website you could check out for blogs like this and a lot of other useful information, NashuaLaw, one word, .com, NashuaLaw.com. Look forward to working with you if the opportunity arises. Thank you.